Hi, everyone. Welcome to the Hammer Museum's online Constitution Happy Hour. It's time to shake off the workday and settle down with a drink and a great book. Constitution Happy Hour is like a book club where we all read the Constitution together. In the real life version, we have a bar and snacks at the museum, and everyone gets a free copy of the Constitution to take home. So for our virtual incarnation, I hope you've mixed your own cocktail of choice, and we'll have the relevant text from the Constitution for you in the slides and pasted into the chat. We're going to have a speaker talk about today's topic for about 20 minutes, and then we'll have a Q&A discussion for another 20 to 25 minutes, and the whole program should be around 45 minutes. When we get to the Q&A portion, if you have a question for the moderator, you can raise your hand digitally with the blue button, or you can type your question into the chat box below at the bottom of your screen. We'll also be looking for physically raised hands during the Q&A, and we'll try to get to everyone's questions, but we apologize if we can't get to all of them. So now I want to ask you to please switch to speaker view. That's in the upper right corner of your screen. Also, please note that this program is being recorded and will be available on the Hammer website. So if you choose to keep your video and audio on, you may be visible and be recorded. And you can opt out by shutting off your camera if you wish. So the Hammer's Constitution Happy Hour is part of a larger project called My Daily Constitution, created by the LA-based artist Linda Pollock. The idea is to bring people together and engage in creative dialogues about democracy and society. Linda first began My Daily Constitution in 2002 in response to the Patriot Act, and since then she has initiated Constitution cafes in bars, libraries, cafes, parks, restaurants, churches, and other places where people gather. To quote Linda, "Our Constitution, our democracy is about interpretation. And interpretation means a collective, active dialogue, not just passive consumers and lawmaking producers. The US Constitution is a living document, part of our quotidian life, influencing us in both large and small ways daily." So part of the reason we're doing Constitution Happy Hour at the Hammer Museum is to see how the Constitution affects our daily lives, and we want these programs to be relevant in real time to what's going on. Today's talk is going to focus on the very cases that were argued before the Supreme Court today. Specifically, today the court heard oral arguments about whether or not Congress and a state grand jury have the power to subpoena the president's tax returns. Lawyers for the president argue that in the current case, the only reason for the subpoenas is partisan politics, and thus to grant this subpoena power would set a bad precedent and subject future presidents to burdensome requests for personal information. They also argue that the president is immune from criminal prosecution while in office, so should not even be subject to a state investigation. There's a lot of really interesting back history to the presidential tax return issue, which includes the Civil War, the Teapot Dome scandal, Richard Nixon, and the 16th Amendment. And we're all lucky to have a brilliant legal scholar here today to break it all down for us. Professor Jessica Levinson studies the law of political process, including election law and governance issues. Her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. She regularly appears as a legal and political expert on television and radio and in print. She's the co-host of the new podcast, The Legal Eagle Files, and has a weekly legal segment on the Los Angeles NPR station KCRW. She's also an op-ed contributor for NBC.com and the associate director of Loyola's Journalist Law School. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018. She's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. So hello, welcome, Jessica Levinson.
Thank you. Thank you so much for having me. I am so excited to do this Constitution Happy Hour because in part, this is such an important case that we had always planned to talk about, but in part because we actually get to talk about it almost real time. And we have a couple of historic firsts. So the historic first, obviously, this is only the second week where we have ever had Supreme Court arguments over the telephone. You can essentially have a conference call with Supreme Court justices now. And it's only the second week where we have been able to listen live. Typically, it's only in extraordinary circumstances where you can even get the audio later that day. Now we can listen in real time. One of the big questions for you following along at home and maybe listening to the Supreme Court arguments or thinking about the fact that we're having these historic first Supreme Court arguments is what will happen as a result of the fact that we could all hear a flush last week on the telephone? Will this force Chief Justice John Roberts to pull back and say, never again are we opening our virtual doors? But today there were no such snafus at the Supreme Court. Instead, there was over 3 hours of really substantive arguments about this politically charged case. So I'm going to lay out a little bit of background, and then I'm actually just going to talk about each case in turn. But before I do that, we're going to try something a little different from what we did 2 weeks ago. I'm actually going to call up a poll, and we're going to do the same poll at the beginning, and then we're going to do it again at the end. And I want to see if your opinion on any of this changed. So without further ado, I will seamlessly, hopefully, call up the poll. And hopefully everybody should see it. Claudia will nod if that's the case. Okay, you can see it. Right now we have, okay, here we go. Now we have some participation. It's kind of like class. Somebody, anybody, raise your hand. Great. Wow, what an optimistic group in some ways. Nope, you're becoming very pessimistic right before my eyes. Okay, I'll give it a minute. So the questions are basically, should presidential candidates release their tax returns? Will we see President Trump's financial records before the 2020 election? And under the Constitution, does Congress have the power to subpoena the president's financial records? All right, I'm going to give it about 10 more seconds. It looks like we have almost 100% participation. And all right, that's a full minute. I will call it. I'm going to end the poll. Now, while I'm doing that, think to yourself what we're going to see. And I'm going to share results. All right, so real time, 99% of you think that presidential candidates should, in fact, release their tax returns as a policy matter. 82% think that the president's financial record, we will not see the president's financial records before the 2020 election. I agree with you. And almost the same, just under that, 79% think that Congress has the power to subpoena a president's financial records. So I'm going to stop sharing, pull that down. We're going to talk, as Claudia said, for about 20 minutes. I think I neglected to say thank you so much to the Hammer Museum for putting this on, for gathering all of us, for allowing us to have this almost simultaneous with the Supreme Court discussion about these important issues. So background about the cases, which I think you all already know. President Trump, when he was candidate Trump, did not release his tax returns. Now, why do we want that information at all? We want that information because it tells us something about the candidate. It tells us who they might be indebted to. It tells us whether or not they're charitable. It tells us something about whether or not they might have financial conflicts of interest. It paints a fuller picture of the person. But presidential candidates are under no legal obligation to do that. And so President Trump, for I believe the first or second time in modern history, did not release his tax returns. Now, that's part of the reason why we get to these cases, because Congress and a state grand jury have subpoenaed not the president, but the president's accountants or the president's lawyers, the president's lenders at Freudian slip, and asked for this information. Now, why is this in the Supreme Court? In part because we don't have a good answer, meaning this specific question has never come up before. Now, why has it never come up before? Because typically what happens is, one, presidential candidates release their taxes. Two, if a sitting president gets wind that Congress wants their financial records, then they will enter a negotiation to try and give those financial records before you get a subpoena, because presidents don't like the word subpoena in relation to their personal financial records, or most presidents don't. then next, even if you do get a situation where a president's financial records are subpoenaed, what very, very typically happens is there is some sort of negotiation, or legally speaking, it's called accommodation between Congress and the executive branch. It's very rare that what happened here happens, which is President Trump just says, absolutely not. It's a wholesale rejection of Congress's and the state grand juries subpoenas for this information. And the question is whether or not Congress and the state grand jury constitutionally have the better argument. This is where I want to say, whatever you think about the case, and I know it's so hard, but trying to actually take politics out of it. This is a legal question with huge political implications, but we should have the same answer, really, regardless of whether or not there's a Democrat or a Republican in the White House, and regardless of whether or not it's a Democratic controlled House or a Republican controlled House. In the sense that these legal questions really go to the reach of legislative authority over the executive branch, or a state grand jury's authority over the executive branch. We should really, I know it's almost impossible, but try and separate that from, do we want to, as a policy matter, see President Trump's financials? So that's the background. I'm going to now jump in and talk about each case. And I'm actually going to ask if we could call up slide number 1. And we already talked about this a little bit. This is kind of the overarching, are we going to see Trump's financial records? I also want to point out that even if they are turned over, it might not mean that we as the public see them. But let's get back to that in a second. Let's call up the next slide. And so this slide deals with the first 2 cases. So as I said, there are 3 cases overall, 2 dealing with congressional committees that have asked President Trump's accountant in one case and lender in another case for these financial records. And then the 3rd case deals with the state grand jury, and they have asked the president's accountants for financial records. So let's take the first 2 cases first. Those are the cases that deal with the congressional committees. And these cases bring up a couple of really big constitutional questions. I mean, honestly, you could do a whole con law semester just based on what happened in the Supreme Court this morning. So the first kind of, again, we're just talking now for a few minutes about the congressional cases, the congressional committees that asked President Trump's accountants and lenders for financial information. And these cases bring up basically 3 big questions. One is the separation of powers, and related to that, checks and balances, which, and we all know that in our system, we have 3 separate branches of government. We have the legislative, executive, and judicial in that order. And our system of government is essentially based on the idea that we trust you, but we don't trust you all that much. And that's why the congressional branch has some oversight authority over the executive branch. That's why the judicial branch has some authority over both branches, where they can say if actions either violate the Constitution or violate a federal statute. And so our system is set up so that, yes, we have somewhat different silos of power, but we also are under the assumption that we don't want any one of those 3 silos to have too much power. So related to that broad question of separation of powers and whether or not the congressional branch really can act as a real check over the executive branch, we have this question of congressional oversight, which is the way that Congress acts as a check against the executive branch. We know that Congress has some investigation authority. We know that Congress, obviously the kind of nuclear option when it comes to oversight authority, really is the impeachment process. And I was lucky enough to talk in real life at the Hammer twice about the impeachment process. So these cases bring up issues of congressional oversight. And then finally, there's this really interesting issue of, is this a political question? Meaning, are the courts not actually, should the courts not be involved at all? Should they, basically the executive branch and the legislative branch, take this fight outside? So with that, I want to take down this slide for a couple of minutes, and I want to talk in a little bit more depth about these two congressional cases. Forgive me while I look at my notes for a second. So the first case deals with a House committee asking President Trump's accounting firm, his accountant, for financial records. And as a congressional committee, obviously you need a reason for asking for that information. So what the committee said is, well, we obviously, as members of Congress, legislate. And so we have a legislative purpose for asking for this information. Our legislative purpose is that we have to make sure if government ethics laws are really sufficient. And therefore, we need to look at President Trump's full financial picture before he was president, make sure that all of our ethics statutes and codes are up to date. President Trump responds and says, that's ludicrous. That is not your true purpose. Your true purpose is just to try and find out if I did something illegal. And there's another mechanism, Congress, for you to do that. If you really think I did something so bad, you should go through the impeachment process, or you should leave this to the courts after I'm in office. So in sum, on this first case, President Trump has said, you have no legitimate legislative purpose for doing this. You're just on a fishing expedition. Second case, different House committee asked the president's lenders, Deutsche Bank and Capital One, for financial records. In this case, they say they are actually going through an investigation, and they're looking at whether or not there's foreign influence in our elections or was foreign influence in our election. And they need the president's full financial picture in order to make that determination. Here, President Trump again responds by saying, Congress, you've exceeded your authority and that you are not law enforcement. Again, you're just on basically a partisan witch hunt, and you don't have the constitutional authority to do this. So let's pause for a minute and think about the Constitution. Now, a couple of things to remember. Nowhere in the Constitution does it use the word separation of powers. Nowhere in the Constitution does it say congressional oversight. Nowhere in the Constitution does it say system of checks and balances. So what we're talking about in this case, when we're talking about congressional authority, is implied authority. And you saw this come up a couple of times in oral argument this morning, particularly from Justice Clarence Thomas, who we don't typically hear from. And he basically said, show me in the Constitution where Congress has this power. And the answer is, it's not written anywhere in the Constitution. It's understood based on the structure and meaning and history behind the Constitution. Those explicit words aren't there. So let me say, based on listening to the arguments this morning, I think the arguments went well for President Trump's attorney, went well for the Department of Justice, who have joined President Trump's attorneys in opposing these subpoenas. And I think they did not go particularly well for the House, which is another way of saying, I think that for this set of cases, just based on oral argument, and it's hard to predict based on oral argument, for this set of cases, it does look like President Trump and the Department of Justice would come out ahead. You heard the justices kind of saying, well, what's the limiting principle here? And so one of the big arguments was, maybe when you ask the president or the president's accountants or the president's lenders for information, even before that person was president, again, these are all financial documents dating before, or mostly dating before the president was the president. Maybe you need a little bit more of a reason. Maybe you need what we call a heightened standard. And maybe you need to have tried every other route first. So one of the interesting things when I was listening to oral arguments this morning is this idea that I think when it comes to the House versus Trump, meaning when it comes to Congress versus Trump, I think there's a possibility that the court might say, we think you need a higher standard when it comes to the president. And so we're going to send this back to the lower courts. And the lower courts are going to have to decide whether or not Congress satisfied that higher standard. This would have a practical, kind of happy implication for the Supreme Court because they would avoid a decision going into an election year. And I think that the Supreme Court, for a lot of reasons, would like to kind of lay relatively low when it comes to this, and would frankly relish the idea of sending this back to the lower courts. Now, what happened in the lower courts before these two cases came to the Supreme Court? President Trump lost. So he lost in both cases in the district court, and then he lost again in both cases in the Court of Appeals. But as we all know, things can change when you get to the Supreme Court. So that is basically what the arguments are when it comes to the two congressional committees asking for information from President Trump's accounting firm and from his lenders. Looking at the time, I'm going to put a pin in a longer conversation of those two cases, but there's a lot more to talk about. Very happy to answer any questions on that. And so I'm actually going to move to the state cases. So could we call the slides back up for a minute? And this deals, so again, there were three cases. We just talked about the first two cases dealing with congressional committees. Now we're going to talk about the last case, the third case. And this case deals with a state investigation into potential wrongdoing by President Trump. Specifically, what they're looking at is the hush money payments that were paid to people who were alleged to have affairs with President Trump, and whether or not those payments violated any state laws. So there's a state district attorney, Cy Vance, and he essentially asked, the grand jury is going through an investigation, and the grand jury, as part of this investigation, has subpoenaed President Trump's accounting firm for the information to try and figure out if President Trump, when he was candidate Trump, did in fact break any state laws. And this case brings up separate but related constitutional issues. And we'll talk about those each in turn. The first one, is the president immune from prosecution? And I'd add to that, and/or investigation while in office. The second question talks about the Supremacy Clause. And the idea behind the Supremacy Clause, which I'll ask to call up in a second, or actually maybe we can just call it up now, well, that's the next slide, while I'm talking, is that when there is a conflict between the federal government and the state government, the federal government wins. When there is some sort of tension, if there are either potentially two laws that are in tension, two investigations that are in tension, we know who wins. It's the federal government. So there's actually kind of a horizontal government battle that's happening in these cases, and then there's a vertical government battle. The horizontal government battle, it deals with the first two cases we talked about in terms of Congress, where you have Congress, the executive branch, and the judicial branch. And there's a question as to where the authority and power between the congressional branch and the executive branch butt up against each other and who wins. In this in this third case, then there's more of a vertical tension between the federal government and the state government. So with that, I'm going to ask to take this slide down, and I want to talk a bit more about this third case. Again, this case dealing with the New York grand jury, state grand jury, subpoenaing President Trump's accounting firm for financial information. And so, again, what New York has said is, we need this information, and we need this information now, because evidence can become stale, people's memories can fade, people can lose documents, and the statute of limitations, meaning the time within which you have to charge people for people other than the president, might run out. So we can't wait until the president is out of office. President Trump has said, yes, you can and you need to. And this is where President Trump is making a really aggressive argument constitutionally. He's saying, not only am I immune from prosecution under the Constitution, which is something we talked about a lot with respect to the Mueller investigation, whether or not the president is actually immune from indictment or prosecution. I will say, again, the Constitution is silent on that. We don't know the answer. We can argue it out both ways, but nowhere in the Constitution does it say the president is immune from indictment or the president is immune from prosecution. So President Trump is saying, not only am I immune from indictment or prosecution while I'm in office, but I'm also immune from investigation. And that is much more forceful than any argument that we've previously seen. And that would mean essentially, even if you think a crime has just been committed by the president, you could not go through with an investigation. Famously, when this case was argued in the lower courts, there was, I believe, an up and back between the lawyer, President Trump's lawyer, and the judge, where it went back to that famous example of, what if the president shoots someone in the middle of Fifth Avenue? And President Trump's attorney's response, assuming I'm remembering this right, was, you can look into that after he's out of office, but he has absolute immunity. And so in this case, the argument did not go as well for President Trump this morning. I think you saw the justices, maybe at least 5 justices, thinking that the president just had gone too far in his argument, that he was immune not just from prosecution and indictment, but also from an investigation. And this is where you saw the justices, I think, struggling a lot more, and it looked better for New York State than it did for the House. Now, one more thing I want to mention. I want to go back to the first 2 cases for just a minute. I mentioned this before. I should have mentioned it again. The Supreme Court on April 27th asked the Congress, President Trump's attorney, and the Department of Justice, meaning all 3 parties to that case, for additional briefing on the question of whether or not this dispute, whether or not this fight actually falls within the political question doctrine. None of the parties had argued it. The Supreme Court itself asked the parties to brief it, which is a great indication that the Supreme Court is looking for a way out. The political question doctrine, as I said briefly, basically means that judges don't have any role in deciding that dispute. And the standard is either that the Constitution gives authority to somebody else to make the decision, not to judges, or that there's really no workable standard, meaning no good way of judging that dispute. When the parties turned in their briefs, I think it was 3 days ago now, all of them agreed the political question doctrine does not apply. And you didn't actually hear that many questions on it this morning. Again, what did you hear more questions about? This issue of whether or not maybe there should be a higher standard for subpoenas when it comes to the President of the United States. All right, with that, I believe I broke Claudia's word just a little bit, and we went slightly over the 20 minutes. But I do want to bookend this with the other polls, and then we'll go into what I hope is a really robust Q&A. So I'm going to try to somewhat seamlessly relaunch the poll. I'm going to look up at Claudia for a nod if you guys can see it. Okay, I got a vigorous nod. So, and I wanted to see a little bit for myself, a little bit for all of us, whether or not our minds changed at all having heard me talk about the three cases. And so I'm going to give it just a couple minutes. I see a lot of people participating. Let me take this moment to say, please be as vigorous in your participation on November 3rd as you are right now. I think since we last saw each other 2 weeks ago, there has been a new executive order by Governor Newsom for you watching in California that you all will receive vote by mail ballots. And let me say that I think that you should feel very comfortable using that mechanism to vote. Those are not systems that are ripe with fraud or corruption. We have maintained a great level of integrity when it comes to our elections, and you should feel very comfortable using vote by mail ballots. And with that, I'm going to end polling. Things did shift a little bit and share the results with you. So, question number one about, as a policy matter, should presidential candidates release their tax returns? That stayed about the same. A few more of you actually think we might see President Trump's financial records before the 2020 election. Let me take this moment to say that if the documents are turned over to a congressional committee, I think there's a great chance that the public will see them quickly, because I think a member of Congress could basically walk down the hall or walk down a virtual hallway, hold up the documents and say, who has a camera, or who has a TV camera right now. When it comes to the last case, the New York grand juries proceed in secret. And so if we ever saw those documents, it would not be soon. And then finally, a little bit more of a split under, does Congress have the power to subpoena a president's financial records? All right, so with that, I will stop sharing. I will close the poll. And at, I believe, almost exactly 25 minutes in, I will say, I'd love to hear from you with any and all questions. Any and all questions, hopefully Supreme Court and Trump tax return related.
Yeah, so that was fantastic, and I learned so much already. I want to tell the audience that you might want to change your Zoom settings to the gallery view that's in the upper right corner. That way you'd get to see all your fellow audience members as well as Jessica Levinson.
I just did that. Hi, everybody.
Hi. We want this to be as interactive as possible, so we've 3 ways that you can ask questions. You can either raise your hand to ask a question out loud by raising your hand digitally with the blue button, which is in the participant window. Or we're also going to be looking out for physically raised hands in the videos. So if you actually raise your hands, we have people looking for you. And when we call on you, we're going to unmute your audio and you can go ahead and ask your question live. Alternatively, you could also type your questions into the chat box below at the bottom of the screen, and I'll read them aloud to Jessica. If you already typed your question into the chat, but you'd rather ask it directly out loud, please go ahead and raise your hand now. We're going to try and get to everyone's questions, but we apologize if we can't get to all of them. And just a quick reminder, this is being recorded, so if you don't want to be recorded, please turn off your video and you can still type your questions into the chat box at the bottom of the screen. So I'm now going to take our first question that came in earlier. This comes from David Holtzman. He says, would the Supreme Court be more likely to uphold a subpoena from a federal court rather than the state court?
So neither one of the subpoenas are coming from a court. They're coming from either a House committee. First of all, hi, David. Good to hear from you. It's been too long. They're either coming from a House committee or from the state grand jury. And they both bring up federal questions. So I think that, in fact, it just deals with whether or not the Supreme Court is more likely to find that Congress overstepped its authority or a state grand jury overstepped its authority. I will say that the lawyer for the House committee this morning, I don't think did Congress any favors, where he basically said, I'm not sure the justices said, we're really worried that you can, subject a president to way too many subpoenas, that it'll be difficult for the president to really execute his duties, and this could be harassing. And the attorney did not really come up with a good limiting principle. So if I were going to guess this morning, the House loses, or you send the cases back down to the lower courts to determine based on a higher standard. But I think New York State probably wins.
Awesome, thank you. So next we have a question from Ellen Brooks. Ellen, you are live.
Thank you. I have a question that that you didn't really make clear. Where does the House of Representative committees and such get their subpoena power privileges, if not the Constitution?
Yes. Hi, Dr. Brooks. Thank you for that question. I'll see you on Zoom for our Thursday call as well. So this is a great question. Where does Congress get its subpoena authority? And the question indicates to me that I was not particularly clear. So the authority comes from the Constitution, but it's not explicitly written in the Constitution. So if you look back well over a century, if you look at Supreme Court cases, we operate under the assumption that implied in our structure of government, implied in the idea that we have a government of separation of powers, implied in the idea that we have a government of checks and balances, we say that Congress has two big powers. One is the power to legislate, and the other is the power of oversight, particularly of the executive branch. And what the Supreme Court says very specifically is, if we're going to imply this oversight authority, which makes all the sense in the world because Congress obviously has the power to impeach a president, Congress would also have the lesser oversight authority. If we're going to imply that oversight authority, then you need to actually be able to oversee. You need to actually be able to investigate. How do you investigate? You use a subpoena, which is a request either for a person or for documents, in this case for documents. So it's not written in the Constitution, and that's what you heard Justice Clarence Thomas, as I said, really going back centuries, and we've understood this for centuries, that Congress has this implied power and saying, are you sure? But we've understood it. Every Supreme Court has said, yes, you must have that power, you must have that constitutional power, even though it's not written. You look semi-satisfied. Okay.
All right, the next question is coming from my old friend Double G, otherwise known as the famous composer, Jeffrey Gallegos. Hey, Jeffrey. You are live. Oh, there you go. You're
Check one.
Hey.
Hello, good to see you.
Good to see you.
I have a question. Thanks, Professor Levinson, for this conversation. My question is with a tax case. Since Congress has the express grant of authority to tax and spend, could they subpoena the tax returns as business records kept in the ordinary course of business?
Yes, good to see you. Always good to have a very well-informed question. So could they subpoena these in the ordinary course of business because Congress has taxation authority? My understanding is that that doesn't really bleed over, in the sense that the authority to tax and spend is they're seen as a, I hate this expression, but kind of Chinese wall, where on the one hand you have the power to levy taxes, but then on the other hand you have the power to investigate the president. The other complication is we all say Trump's taxes, and we all say, we want to see the tax returns, but what Congress is actually asking for is much broader than that. It's for financial records dating back, I believe, to either 2009 or 2010. It's not just for the tax returns. Now, there is a law which indicates that the head of a congressional committee can ask for the tax returns. I think you know this. I think we actually may have interacted about this. Can ask for the tax returns of any taxpayer. But that is a different route from what we've seen in this case. And that would mean just that the head of that congressional committee sees it. And we still have the problem of a legislative purpose. So that was a long way of saying Congress can have power to ask for things, but what I think we're really dealing with here is you still need to hook it to legitimate legislative purpose, which I want to say, I didn't get into this, but we used to understand as you could be envisioning any legislation that might be on the horizon, and that would be enough. It's a very low standard, or oversight authority that doesn't exceed Congress's power. So that's a very long way of saying, my understanding is no, I don't think so.
Thank you, Double G. Our next question comes to us from Brian Belansky. Are you live and ready? Brian, are you ready to go?
Okay, there we go.
Hi, Brian.
So first, hey, Jessica, how are you?
We've been seeing each other in person for quite a while. This is the Q&A where I happen to know everybody asking a question.
So first of all, you've kept my 14-year-old daughter engaged for 45 minutes.
Oh,
so you should
hi.
be impressed by that.
Bravo.
I'm so happy to hear that.
But my question is there a precedent for either a state or Congress subpoenaing records from a sitting president from before, whether they're business tax or otherwise, from before he was in office?
Yes. So the question is, I think everybody heard it, but basically, has a state, like a grand jury, or have the House previously asked for a president's financial records? And I think that the answer is not in modern history because, as I said, you usually don't get to this point. So this is going to sound like a partisan comment, and it's not meant to be. But typically speaking, you would have a much fuller picture of the president's financials. And we don't have that. Typically speaking, you would not have a president where you have many questions about, for instance, whether or not that president has violated conflict of interest laws if they apply to the president, whether or not there's emoluments clause violations, whether or not there is foreign influence into the election. And so there are all these things that make this president, frankly, different. I don't remember in modern history that we had a president where there was an inquiry as to whether or not payments, hush money payments to someone who's alleged to have an affair with the president, might have violated state laws. I don't remember a situation where we had a president who had this many potential financial dealings that raised legal issues prior to when this person was president. We have seen, so I think the short answer is, if it happened, I'm not remembering right now. And let me just say, Brian is an amazing producer at CBS LA, and that's how we know each other. And I'm really proud to know him and happy that your daughter hung out all this time. So what we do have in terms of precedent is the Clinton versus Jones case. And I didn't have time to really talk about that, but in that case, it was Paula Jones, who civilly sued a sitting president, President Clinton, for sexual harassment. So that was a civil suit. And President Clinton said, I can't be sued. I'm immune from this suit while I am in office. It infringes on my ability to do my job. And even though everything took place, I believe, before he was president, it is still something that you just have to push pause on and wait till I'm out of office. And a unanimous Supreme Court with two of his appointees, Justice Ginsburg and Justice Breyer, said that's not true. Now, this case was brought up a couple of times this morning because what the justices asked the attorneys was basically, okay, so if we can force a president to respond to a deposition in a civil case, subpoenas in a civil case, how is it that it's so much more burdensome to allow third parties of a president, not even the president, but the president's accountant or the president's lenders to respond? And they said, isn't it actually a lot more burdensome to have this suit to try and prevent them from responding? Which is all a very long way of saying, I don't think that there is the situation that you talked about, at least not that I'm remembering, but we do have a good past example which would indicate that this really isn't too hard for presidents to at least allow accountants and third-party lenders to respond to a subpoena. Thank you. Claudia, you're muted.
Sorry. I'm not sure if we've already answered this 6 ways from Sunday, but we have a lot of questions about presidential immunity and where does it really stem from, and what is it really, and what is the deal?
Yes, I did not hit on that today because that can be a whole other topic. So I think the question broadly is, and I just mentioned it because it's a part of that third case, the case dealing with whether or not a state grand jury can ask the president's accountants for the president's financial information because there's an investigation. And I said that there's kind of an understanding that presidents are immune from prosecution or indictment. And then I didn't say more than that. So now let's, at this moment, say a little bit more than that. As I did say, I think it does not anywhere in the Constitution explicitly say the president is immune from indictment or the president cannot be prosecuted while in office. This is something that has actually been recently very hotly debated. And there are, I believe, 7 Department of Justice from the Office of Legal Counsel memos on this issue. And there's a couple of different ideas for why the president would be immune from indictment. One of the arguments is that this would cast too much of a cloud over the presidency, and the president couldn't possibly function. So you could have a situation where you have a rogue prosecutor, and that prosecutor essentially is too aggressive and ruins the presidency because that person has indicted the president. Another is the idea that it would simply be impossible for the president to fulfill all of his or her, at some point, her executive duties and still respond to a criminal case. Now, you could actually solve that by saying we're going to indict, but we're going to pause the proceedings. And there's a lot of literature on that argument. There are other arguments dealing with whether or not, basically based on the structure of the Constitution, it would be fair to allow for an indictment of a sitting president. But most of the arguments deal with this idea that it would infringe on the president's ability to serve the American public. And so if you look at the way Article 2, which is the article that creates the executive branch and creates the powers of the executive branch, if you look at the way it's structured and the powers that are given to the president, Office of Legal Counsel says there's at least a good argument that you can't indict a sitting president. Special counsel Robert Mueller did not engage in a discussion about whether or not that current understanding is correct. He said very clearly in the report, we always operated under the assumption that that was correct. So I know this feels like about 2 decades ago. I think it was actually maybe somewhere between about a year ago when the Mueller report came out. There was never going to be an indictment. This was always going to just be providing information to Congress about whether or not Congress wanted to impeach the president or not. So I answered that maybe 3 ways to Sunday, but not 6.
Okay, we have 3 questions here that are related to each other. They're all have to do with maybe trying to fix the Supreme Court or how the Supreme Court operates.
Yeah.
From Victor Costa asking what's the probability that we could change the Supreme Court to allow more justices or to use a new process to choose the justices that's more bipartisan and not just picked by the president. We also have a question whether if there's any evidence that this particular Supreme Court that we have right now, is there evidence that they're going to be bipartisan? That's coming in from Eva. And then Charlie asks us, how does the interpretation of the Constitution differ in this Supreme Court from the most conservative to the most progressive judges with regards to this case? Sorry, that's maybe too much for one question.
No, well, those are great. So maybe I will ask if I'll start answering, and then you'll remind me part of or all of what I forgot, perhaps. So let's take this really big topic, which we could easily do a whole forum on how to fix the Supreme Court. And so the Supreme Court is actually a great example of how our separation of powers, where we talked about, legislative branch, executive branch, judicial branch, they're not completely different silos. There's actually a lot of interaction and overlap. So the president obviously is the person who nominates a Supreme Court justice, not just a Supreme Court justice, but all federal judges. And then that person is able to get their job, assume the bench based on the advice and consent of the Senate. This is obviously inherently a political process because you have two, by definition, political actors. You have the President of the United States and you have the Senate, who have to come to some sort of resolution. And I think recently we saw one of the most aggressive political moves that I think we've ever seen in modern history, where Justice Antonin Scalia passed away in early 2016, and the Senate Majority Leader Mitch McConnell said, "We will not hold hearings for your nominee, Merrick Garland." President Obama, basically, good luck to you. And of course, Senator Mitch McConnell won that argument, and the seat was left open until President Trump could fill it. So that's a long way of saying, are there ways to fix the Supreme Court to make it function a bit better? I mean, of course, it's my better is somebody else's worse, but I would say absolutely. So there's nothing in the Constitution that says you have to have 9. We have actually had, we've had less and we've had more. Article 3 judges are judges who sit for life, but you could change that. So one of, I think, the best proposals is to actually have a rotating system where you have term limits of about, let's say, 13 to 18 years or more, where, now it looks like when you appoint people, one of the most important things is you look at their age, and you look at like an actuarial table to make sure that they'll be on the bench for a long time. And so a term limit would change that. And it would say, you don't get a lifetime appointment, but you get this job for a very long period of time. And if you stagger those terms, then you also, I think, you spread out the power among presidents. So as it stands, you have certain presidents who can appoint 2, 3, even 4 justices, other presidents who have appointed no justices during their terms. And appointing a Supreme Court justice is one of the most consequential things that a president can do. I will also say, the vast, vast majority of cases are decided by lower court judges, and they are really important. How do we know they're really important? Senator Mitch McConnell called the Senate back essentially from quarantine, from self-isolation, so that they could have hearings to push more of the federal judicial nominees through the process, through the Senate. So if you ever wondered whether or not it's important, we've called the Senate back into session to make sure that we can essentially keep filling those vacancies. So that's a long way of kind of getting to the answer of, I think the best, most elegant solution isn't actually the number of justices, it's changing their term. So they have a finite term and they're staggered. So every president, for instance, gets 2 or 1, but 2 would make more sense, gets in each term, in each presidential term, gets 2 nominations. That would take actually a lot of the politics out of the process, because the Senate would know every president gets 2, the president would know, and it would allow for a completely different process. Now, in terms of the kind of makeup of this branch, I would say, or excuse me, makeup of this court, this is kind of the one thing I would say. Ruth Bader Ginsburg is viewed as the left side of the left wing of the branch of the court in many ways. But if you look over history, I think you would really put Justice Ginsburg left of center. But she is not, in my opinion, a radical liberal justice. It's that the rest of the court has shifted beneath her. And so the current conservative members of the court that you see are much, much more conservative than what we saw 30, 40, 50 years ago. And so she's now much further to the left, whereas when she was appointed, you saw a bunch of newspaper articles saying President Clinton nominates moderate Justice Ruth Bader Ginsburg. None of us really think of her as moderate now. Same with Justice Breyer, who President Clinton also nominated. So it used to be that, for instance, Clarence Thomas was seen as far to the right, kind of outside of the right wing almost of the Supreme Court. Now I think he's much closer to mainstream conservative thought. So the court has really just pushed rightward.
Wow. Okay.
Wow, that was a lengthy answer.
Yeah. I have another question about the Supreme Court. But before I ask it, I want to first say that we've referenced, Professor Levinson has referenced a bunch of specific passages from the United States Constitution today. And since normally you would all have a physical copy of the Constitution if we were at the Hammer Museum that we would give you, I'm going to ask our staff to paste the text from those passages into the Q&A box. So those will be available for you in a moment in the Q&A section. And we just have a few more questions. We're almost out of time, so I'm going to go through them really quickly. The first one is asking if there's a conflict of interest within the Supreme Court. I don't have the person's name, but they ask if there's any discussion about retired Justice Kennedy having a son who worked at Deutsche Bank, which was responsible for Trump's portfolio, and is that a conflict of interest?
Yeah. So I heard you say we'll go through the questions shortly, which I also took to be a nod of let's go through the answers quickly as well. But so the short version is that there is a conflict of interest code, that there's a code of judicial ethics that applies to every federal judge except 9. And those 9 are on the Supreme Court. The code of conduct applies to Supreme Court justices in a suggestive way, but not a mandatory way. In part because who would ever enforce if the Supreme Court did not follow that code? They're really the end of the road. And so they typically will follow that code, but not always. So it's not incumbent upon them that they have to recuse. Justice Kennedy obviously
be impeached, right?
They could be impeached, absolutely. That would be a really rough road to plow. But yes, absolutely, they could be impeached. But I don't think that that type of conflict, that raises more of a political and ethical question. I'm not, for a retired judge and for a adult child, I don't think that that would fall within. I would say that a lot of lower court judges who I know would probably say out in an abundance of caution, somebody else is going to make that decision.
Okay. Susan Blanchard asks, is there any discussion in Congress to pass legislation requiring candidates for president, vice president, senator, or Congress to release their tax returns for a period of time, for example, the past 10 years? Which I think there is, right?
Yes, there is. We're going to try and do this one really quickly. So the Constitution actually sets the qualifications for presidential candidates. And essentially, you have to be a certain age, you have to be a citizen, a natural born citizen. And we can't really add a qualification into the Constitution, at least not easily. So California actually tried to get around this by saying, well, if you want to be a presidential candidate, or later they also said gubernatorial candidate, and you want to be on the ballot, then your route to the ballot includes a threshold requirement of releasing your tax returns. And there were two parallel cases that went up, one under state law to the California Supreme Court, one under federal law to the federal district court. But the state court decision was made first. And what the state court said is, no, even under the California Constitution, that's not proper. Which is, there's so much more to say on this, but I would just say, you get into a constitutional problem of adding a qualification to the office that is already defined in the Constitution.
All right. I have two last questions. I'm saving what I think is the most interesting for last from Andrew. But first, we're going to take a question from Andy Reimer. He says, the time given to these cases, and perhaps to all Supreme Court cases, is so limited that it seems absurd that a decision is made on such a truncated hearing, especially for matters of such great importance. So to what extent do these justices rely on briefs, and how much weight is given to oral arguments versus written arguments?
So I was listening to the oral arguments this morning, and I was following along on Twitter, and a lot of people were saying a version of this argument when it came to the House and President Trump, that this argument is a good example of that you can't win a case based on oral arguments, but you might be able to lose a case based on oral arguments. So I think that the question is exactly right in the sense that justices and their clerks, who are key to making the decisions, rely very heavily on the briefs. And Justice Clarence Thomas, in fact, prior to the last 2 weeks, I think he asked a question last year and before that, not for the past 10 years. So he didn't engage in oral arguments, but was clearly still a powerful force on the court, which is another way of saying it feels incredibly fast during oral arguments, but there's no constitutional requirement that you would have these arguments at all. You could decide everything on the briefs. And a lot of times in looking at the decisions, I think oral arguments may appear a lot more important than they are.
Thank you. Okay, so I'm going to ask the last question. Before that, I just want to announce that next Tuesday at 5 p.m., we're going to have a Hammer Forum talking about the Michael Flynn Department of Justice situation. So I hope you'll all come back and join us for that. That will also be moderated by Professor Jessica Levinson. And this final question comes from Andrew. He says, which I think is so interesting, and I'd love to know the answer. Is there an argument that you, Jessica, believe that the lawyers should have made to strengthen their cases on both sides?
So that's a great question. I think that as I said, the worst argument, I'm not used to questions based on my opinion. I think what I would say that maybe I'll kind of punt a little bit and say this: the House lawyer, the lawyer for Congress, I think missed the boat on explaining the fact that these were documents, we're talking about documents before the president was ever president. So we're talking about personal records. So there's no issues of executive privilege. That these are documents where you're not forcing the president to turn anything over. You're forcing the president's accountants or the president's lenders to turn things over. That these are documents where the president does not have to lift a finger in order to do anything. And I think the House lawyer really, in my mind, failed to make the compelling case of, don't think about President Trump, think about anybody living in, or anybody who is in the Oval Office, any president. Do you want to keep expanding executive authority? So if you think of the three branches kind of like a balloon animal, executive authority, not just under this administration, but under other administrations, it just keeps expanding, but there's only a certain amount of power. So the congressional branch is kind of contracting. Think about war powers. Think about declarations of national emergency. And think about increasing in executive orders like the travel ban. All of these areas where executive authority is really increasing. I didn't hear from the House lawyer saying, don't think about President Trump, think about every other president and whether or not you want to keep enlarging this branch. So with that, I see we are well over the 45 minutes promised. I will wear a different outfit for next week. I'm so excited to talk about the Department of Justice and what is happening with Attorney General Barr and the request to dismiss charges against Michael Flynn. And we hope you'll come back for more.
And you're welcome to bring the cocktail of your choice, even though it's not officially a happy hour. I want to thank Professor Jessica Levinson from Loyola Law School and all of the amazing Hammer Museum staff that worked so hard on putting this together. Thank you, audience, for joining us. Have a good night. Bye-bye.